If we could go to the overview slide, Rebecca. Now, there have been some major overhauls of our rules in the past, but this is a really large one, really big overhaul by the Texas Supreme Court. It's going to affect mandatory disclosures. These are initial disclosures that don't require a request. It's going to affect, there's going to be a broadening of the class of expedited actions. It affects experts in pretrial discovery. It affects service of citation, especially alternative service by social media, which is now included. There are 22 changes. 19 are in effect now. Others are pending approval or further commentary. If we could have the sources slide, please, Rebecca. Now then, today, what we hope to show you, we can't explain all of these changes in one day. We're hoping to give you a brief overview and that you will then know where to go. And I was so impressed that these ladies have put together, 3 people that I mentioned and 4 people that I mentioned, have put together this amazing slideshow. It's just very good. So we want to tell you where to go. And we want to tell you that in your sources, you'll notice it tells you the rules. There's a little place there that's circled by Rebecca that says the rules advisory. And you click on that and it'll tell you the commentary and how the rules came about. Lastly, I want to tell you, and I want to repeat what Carissa said, please save your comments for the chat box. And also understand that these rules will be undergoing commentary and changes by appellate courts and et cetera. We don't know what full effect they're going to have, but they're very, very important. So please save your questions for the chat box and we'll try to answer as many as we can. And with that, I'll ask Rebecca to start the slideshow.
Hi, hello everyone. My name is Rebeca Merka. I'm an assistant county attorney at the Harris County Attorney's Office, and I'm happy to be here. So Mac said that there are 22 changes. Let's start with change 1. The first one affects Rule 47. That's claims for relief. So previously, the rule called for lower maximums for claims, and the maximums that were in place were $100,000, and that maximum included things like attorney's fees and costs and punitive damages and things like that, the items that would run up that number. Well, now that is no longer the case. The changes increased the maximum claim for relief to $250,000 and specifically carved out interest, statutory or punitive damages, penalties, attorney's fees, and costs. The second thing that happened to change this rule is that there was a new category that was added for non-monetary relief. This category did not exist before. If you look at the slide, it's a completely new red text item. So now you can have things such as specific performance or declaratory judgment as the type of relief that is sought for under Rule 47. The next change number 2, affects Rule 99, which is the issuance in form of citation. So in large part, the rule is the same. As you can see, there's minimal red lining and red text that's added to Rule 99. The form and the styling of the citation is the same. But the changes that were made track the changes, and you're going to hear this over and over throughout the presentation. The changes track the changes that occur in Rule 194. So first and foremost, you'll see that there's an added requirement that this citation must reference possible required initial disclosures. And so remember that, required initial disclosures, that is the change, one of the changes that you see in Rule 194. In addition, when filing the answer to the clerk, if you look at the very bottom of the red text, again, there's another reminder that you may be required to make initial disclosures to the court and other parties of the suit. So that is the change to Rule 99. Again, for the most part, the rule is the same. The next rule and change number 3 is Rule 106. And this rule, to us, as we were researching it and understanding it, is Texas coming into the modern age of social media, right? So what's happening here is that there is new methods for substituted service. So a court may order, it's not guaranteed, but a court may order substituted service by social media, email, or other technology upon a motion with sufficient evidence. Previously, the rule was limited to more traditional methods of substituted service, but that is no longer the case. And fortunately, this change is, just in time for, well, maybe not just in time because it was effective December 31st, but it is happening during the era of COVID. Now, this change isn't in response to COVID. The changes that we see in Rule 106 were taking place before and were contemplated before COVID affected our nation. But it does help out now that we're working from home and services done. Lots of our work is done more so online than done in person and through printed service. The next change number 4, affects service of process in foreign countries. The changes here are mostly stylistic. There was a lot of superfluous text that was redlined from Rule 108A. There is one change in particular that we want to highlight, and that is that the words treaty and convention were redlined, and they were replaced with international agreement. And that does have an actual impact on the interpretation of this rule, because before, the service of process in a foreign country was limited to, and I believe the text said, at the direction of a treaty and or a convention. Now there isn't at the direction of treaty, just as so long as it's not prohibited by international agreements. So treaties, conventions, and international agreements are all different bodies of law that come into play to help direct the way that we complete our service of process in a foreign country. So largely the rule is the same, but we have what I believe to be a more expansive term here. Okay, for Rule 116, that's our next change. That's change number 5. So this change number 5 and change number 6, the one that we'll see right after, affect service of citation by publication and the return of a service of citation by publication. So in turn, let's start with Rule 16. And here there are significant changes, right? There's so much, in fact, that there isn't a red line copy of Rule 116. It's an entire rewrite. So we had to look at the former rule that was published, I believe, in February 22nd of 2019, and track the new text that's provided in administrative order. And you can see here at the very bottom of the slide, every administrative order that touches Rule 116, we listed here below. And we've done that for every single one of the rule changes in every one of the slides here in this presentation. So what happened to service of citation by publication? If you were to take it broadly, the change here is that Texas is modernizing, right? So before, you're looking at a rule where service of citation by publication was exclusively done through publication in newsprint, right? So if you wanted to invoke Rule 116, the citation that was served was published in newsprint in the county where the suit was pending, or if you're talking about an action involving real property, you had to publish that citation in the county where the property was situated. And you published for 4 weeks and things like that. Well, now you have citation by publication, but this requires the attorney to ensure that the citation is published, and you would guess it because we're modernizing, online. And not just anywhere. The publication has to be done specifically on the Texas Online Public Information website, and that's it's been labeled topics, and the website itself is hyperlinked to this presentation. You can also see it in the screenshot that we have here, topics.texascourt.gov. And whenever you land on that page, you will see the screenshot that you see here. So you see citation by publication if you want to search to see all the service of citation by publication, or if you want to see a protective order. Okay, so what do I mean when I say the attorneys have to ensure? Like, do the attorneys actually have to make the posting? And the answer to that is no. What the attorney has to do is that they have to coordinate the posting with the district or county clerk's office or the court staff, because it is only those three groups who can enter information into the topic's website. In addition, newsprint publication is exempted for certain cases. Okay, so that would be for cases that file a motion under Rule 145, and that's for the inability to afford payment of court costs. There's also an exemption for instances where printing would exceed $200 or another cap that is set by the Supreme Court. So whatever the greater cap is between those two numbers, if you exceed that cap, then you don't have to print via newsprint. Again, the online publication is required irrespective of how much it costs you, but I don't actually think that there is a cost associated with publication via topics. And then the last exempted category is if there is a county where the publication is required doesn't have a newspaper, then you don't need to worry about printing or publishing the citation in that county's newspaper. Previously, the rule stated that if that county didn't have a publication, then you had to go to an adjoining county and publish it in their newspaper. So that's not the case anymore. Also, I want to highlight that the Harris County Law Library, they have guidance, and we researched and found this text that you see here that says a couple of really important things. So the citation that is published has to satisfy the office. I'm going to go back. I believe it's like the Office of Court Administration. That's what it is. So the OCA guidelines, right? And the OCA developed topics. And again, it is their job to create this website for posting and citations and other notices. And while the OCA maintains a website, the content itself from the website is provided by the district clerks, the county clerks, and the court staff. Okay, and searching is very user-friendly here. You search by name or cause number or county, and you find, all sorts of information, including the text of the citation notice itself. So relatedly, Rule 117, the return of citation by publication, that rule was amended. And so before, the rule required that the officer executing the citation was required to show the publication and to show a copy of the publication and to sign the return. But now there's a responsibility shift. So if the citation is served by publication, then the attorney must coordinate with the OCA or with the district clerk or the county clerk or court staff, whoever it is that they're working with, and the OCA will generate the return of citation and specify the publication dates. The return will be sent to the email address of the authorized user who posted the notice. So that means that the email that will include the return of citation and all the information that goes along with it will be sent to, for us in Harris County, that would be the county or the district clerk. So attorneys work closely with the district clerk, the county clerk, and your court staff in order to, whenever you're in a situation that requires Rule 116 or Rule 117. I know there might be a lot of questions about this, and so for that, or even if there aren't any questions, for that, we included some helpful links here. So the website topics, hyperlinked right there. In addition, there is a PDF that was provided by the Texas Courts website, and that PDF includes FAQs and A's. So that's the second hyperlink. And then the third hyperlink is instructions and comments that are specific for attorneys regarding these two rules, and that's the third hyperlink. Okay. The next change is change number 7, disclaimer. This is one of the 3 changes that isn't actually in effect. Commentary is still being received and analyzed, but we wanted to go ahead and expose our office to the changes that happen in 145. So in general, the rule is the same, except that certain evidence here, and just to be specific, Rule 145 addresses motions that are filed for payment of costs not required. So the rule for the most part is the same. There are some changes, and broadly they are that certain evidence is specifically categorized as prima facie evidence. In addition, the court reporter filing the motion under this rule must follow the same requirements as a clerk or a party to the suit. That was a big change. Before, a court reporter didn't have such a responsibility. They really could just file a motion and that was it. So let's go through each one of the changes here. So first I mentioned that there's a certain list of evidence that's considered prima facie evidence. And importantly, that type of evidence is not required when you're filing a motion. But the changes to the rule go ahead and outline what evidence is considered prima facie evidence. The second is that an attorney ad litem cannot file a motion for a party to pay costs. They used to in the past or in the previous version of this rule, but not now. The third, and this is what I was talking about just a little bit earlier, is that a court reporter must file a motion with sworn evidence to require a party to pay costs. Unlike before, the responsibility was, the burden of proof was borne by the party. They were required to prove their inability to afford costs, right? So you see a burden shift there. Furthermore, a party cannot be required to pay without notice and hearing. So that is a requirement. And then the last here is that an order requiring payment has to include a conspicuous notice of a party's right to appeal. And the window to appeal is a 10-day window. So it's pretty quick. It has to be conspicuous, in the order that is received. All right, the next Mac mentioned earlier, and that is the expansion of expedited actions, and that's Rule 169. So that's change number 8. And here, the changes in 169, for the most part, track those made in Rule 47. That was the first rule that we reviewed. So you see an increase in maximum for claims, and overall, the changes make the rule more inclusive of more types of suits. So you see the increased jurisdictional limits and the maximum recovery going from 100 grand to $250,000. And again, that $250,000 excludes interest, attorney's fees, punitive damages, and things like that. So you don't have those items inflating the $250,000 limit. There's also a redlining here. Previously, expedited actions could not include family property tax and the civil rules or civil procedure. Hold on, I'm blanking here. It's like Civil Procedure and Remedies Code, Chapter 47, medical liability claims. Okay, those are a specific carve out, and you can see that in the screenshot here. Now that's redlined, which means that all those actions are now included in expedited actions. So again, an expansion of this category. I looked at the commentary for Rule 169, and the court here says that their hopes here with the changes are in hopes of promoting a prompt and efficient and cost-effective resolution of civil actions. So I think that's a spirit driving the changes to Rule 169. Change number 9 affects Rule 190. And the changes here are many, so main changes, but if I were to categorize them, the main changes are, they affect level 1 and level 2 discovery plans, right? And they change 2 main things: the maximum amounts claimed per discovery plan, and it also dictates, and this is really important, the start and stop of the discovery period. So we're gonna walk through how level 1 and level 2 changed, and then we'll walk through how the recalculation of the discovery period compares to the prior version of the calculation of the discovery period. Okay, so with level 1, the maximum amount claimed, or the value of the marital estate that could be allowed under a discovery plan level 1 was increased from $50,000 to $250,000. Requests for disclosures are removed and replaced with the new required disclosures. That again tracks Rule 194 that we will go over in just a minute. Also, discovery increased from 6 to 20 hours of oral depositions. So it is my understanding that for the most part, level 1 discovery plans, wasn't as inclusive as it could be of a lot of suits, but now it probably could, given the increased maximums and the discovery hours that you can have. Okay, so now to the calculation of the discovery period. So for level 1, it begins when initial disclosures are due. And if that doesn't ring a bell, it probably shouldn't, unless you're very familiar with the changes to Rule 194, because Rule 194 now, the version of Rule 194 that is changed discusses initial disclosures. Prior to this, the beginning of the discovery period was calculated when the suit was filed. Okay, so that has changed. And now it ends after 180 continuous days from when the initial disclosures are due. Okay, and initial disclosures are due, just to give you an idea, they're due 30 days after the answer is filed. Okay, so we're going to go to level 2 and you'll see some commonalities, specifically how the discovery period begins. That begin date is the same for level 2. So if we go to level 2, here we see a bifurcation. You'll see family law cases. Family law cases have one end date. That's it. All other cases, it's the earlier of these two. So with family law cases, much like all other cases and also a level 1 discovery plans, the discovery period window begins when the first initial disclosures are due. And when are those due? 30 days after the answer is filed. Specifically for family law cases, the discovery period ends 30 days before trial. For all other cases, the discovery period ends earlier of 30 days before trial or 9 months after the discovery period. Okay, so what does that look like? How does that really affect our practice? And what it does is that it shortens the discovery period window for cases that are decided under level 1 discovery plans. And it increases the discovery period window for level 2. So let's take a look at it graphically. So if you look here, you'll see a timeline, and the red bar represents the old calculation of the discovery period. And then the green bars represent level 1, level 2 for family law, and level 2 for all other cases. And so I'll walk you through example 1, where both family law and all other cases that are non-family law for level 2, where their discovery period would be the same. And then example 2 will show when they are not. So for purposes of this example, let's just assume a couple of things. And those would be the items that are marked at the very top of the timeline. So we're just going to assume that the suit was filed on January 1st of 2021. We're going to assume that the first answer was filed on February 15th. That would be, if you had attorneys who were like super on top of it and did everything timely. And then we're also going to assume that the first discovery request was served on March 1st. And then we're going to assume the initial disclosures are due on March 17th. And then we're going to assume that the trial date is the first Monday of the following year, January 3rd. Okay, so if you look at the things that we're assuming, the big picture is that you're filing suit January 1st of 2021, and then you're going to try it the first Monday that you can of the following year. And then for purposes of the old rule, you need to know when the initial disclosures were due. That's not really going to be important thereafter. And then for the new rules, we need to know when the answer was filed. So that's why we have all those assumptions at the top. Okay, so what would happen? Under the old rule, your discovery period window begins when your suit is filed. So that's January 1st. And then the next operative date that you need to know is when your first discovery request is served. So for purposes of this example, we said March 1st. And so 180 days after March 1st brings us to August 28th. That is a window of 239 days. Okay. Well, if you look at where you would calculate level 1, you start at when initial disclosures are due. So one takeaway is that the discovery period window is probably going to start about 2 months, just about, depending on your fact patterns, but just about 2 months after you file suit. So the discovery period window no longer starts like a ticking time bomb, like as soon as you file suit, it starts. It's not the case anymore. You have some time. And they start for level 1 and level 2, they start the day that your initial disclosures are due, which is again 30 days after your first answer is filed. And so for level 1, it's from your start date, 180 continuous days thereafter. So what happens? Your discovery window is in 180 days. So first effect is that you see a decrease. And then for level 2, because the trial is set on January 3rd, the sooner of the 2 possible end dates for non-family law cases for level 2 is 30 days before trial. And so what you see is that the discovery period window is 261 days. So in this case, you see the discovery period increase. So what would happen if the trial was set out farther in the future? Like, let's say instead of January 3rd of 2022, the trial was at the end of January. So what would happen in that example is the old rule would calculate exactly the same. Level 1 calculates exactly the same, except that now that the family law case, that discovery period ends 30 days before trial. And if your trial is set to occur on January 30th, then that means that on December 31st of 2021, that's when your discovery period ends. So that's a discovery period of 289 days. For level 2, you would trigger the 9 months from the start of discovery deadline. And so your discovery window goes to 270 days. And so that is, really important change. It affects all of us. So this became effective January 1st. If you filed suit before, you don't have to worry. But if you are filing suit as of January 1st, 2021, this is really important. The next change is change 10, and that affects a permissible discovery. The changes here are minimal, unlike the previous rule. And really what they do is that they track the changes in 194. So it replaces the request for disclosures with required disclosures. And importantly, you can no longer serve discovery until after the initial disclosures are due, unless you otherwise agree between the parties. 193, very similar. The rule is for the most part the same, except for the changes that are made to track Rule 194. So again, you replace the language of requested disclosures with required disclosures. And here there's a requirement that any party, not just the requesting party, return material and specific information if the producing party amends their response to assert the privilege. So what does that mean? So previously, in the previous version of the rule, if a producing party amended their response to assert a privilege, then the requesting party had to return that information, right? Now, if the same amendment takes place, it's not just the requesting party that needs to return the specific information. Any party to the suit needs to return that material info. So that is a change, again, very minimal for Rule 193. The next changes are changes 12 and 13, and these are pretty expansive rewrites. When we were looking at the rewrite of Rule 194 and Rule 195, basically the text is all red. So lots of changes, but if I were to begin with the big picture, hover over the forest before we dive into the trees, these are the takeaways. One is that between the 2 rules, we now have 3 new categories of disclosures: initial disclosures, pretrial disclosures. Both those 2 types of disclosures are covered in Rule 194. And then the last is testifying expert disclosures, and that's covered exclusively by Rule 195. That was not the case before, but it is now. The second change that you see, other than the 3 categories of disclosures, is that the word previously, which was requested, that word requested operative word has been changed to required, which means that now the disclosures are automatic, and that tracks Federal Rule 26A. It's a concept where, let's go into it. Rule 194. The changes here, what they do is before in our practice, we had to, our discovery requests were served upon the other party, right? It was a request. It's not the case anymore. You don't have to await a discovery request from the other party. You don't have to make one, right? These are automatically due. So the first category, initial disclosures. They are due within 30 days after the first answer is filed. And importantly, it triggers the beginning of your discovery period. Later joined parties must provide initial disclosures 30 days after service of suit. One thing that is the same is that all the items that were listed in the previous version of Rule 194, so that's like, party names, telephone, legal theory, settlement agreements, medical bills and records, things like that. All of that is part of your initial disclosures category. Now, you don't have to include testifying expert disclosures in your initial disclosures, okay? Testifying expert information, that does have to be disclosed, but it has its own timeline, and we'll go over that when we go over 195. There is an added disclosure category, and that is, it's a list. Parties must produce a list that contain a description by category and locations of all the documents a party has in its control to support its claims. So I guess that's just like, hey, in spirit of transparency, you have to include this list. Okay, next is that family law cases contain additional disclosures, including tax and financial information and insurance agreements. This requirement, again, only applicable to family law cases. And importantly, initial disclosures requirements do not apply to all cases. There are exempted cases. A child protection action under subtitle E, Title 5, that's exempted, and an action on appeal from the Justice Court. Now, there's a more expansive list, like I think a habeas corpus case or writ for habeas corpus. That's not, that doesn't have to abide by initial disclosures. Now, there is a full list, and it's in 194.2D. That's where it's at. One thing that I want to make sure that I highlight here is that Sandra, I believe you pronounce her last name Hisham. Laura, if you're on here, you can correct my pronunciation. She works at the county attorney's office in the child protective group, and she was instrumental in obtaining this exception. Okay, so she actually petitioned before the Texas Supreme Court to not include child protective cases in these amended rules, requiring the initial disclosures for these types of cases. So that exemption right here is a direct result of Sandra's work.
Sandra Hetcham.
Should have written that down. Sandra, if you're on here, I'm so sorry.
She's brilliant.
All right. So Rule 194 continues, the second category that we were talking about, pretrial disclosures. And if you look at the screenshot that we have here, red text, all completely new. So this is really important. Pretrial disclosures, unlike initial disclosures, don't just have to be exchanged between the parties. They have to be filed with the court. Pretrial disclosures have to be produced no later than 30 days before trial. You can agree otherwise between the parties and have the court approve it, but unless that happens, you are stuck to this due date. Evidence that is used for impeachment solely, that does not need to be included in your pretrial disclosures. Also, your disclosures must include witness information and identification of documents and exhibits. And importantly, this was not included before, a party, when they're writing out their pretrial disclosures, they have to distinguish between their trial and potential witnesses. Like, you have to be super inclusive. And that rule applies also to exhibits. All right, so Rule 195, that addresses the third category of disclosure, and that's expert witnesses. Okay, so one thing that runs the same between Rule 194 and Rule 195 is that expert testimony witnesses, that is automatic. You, again, don't need to await a discovery request. However, the disclosures are due based upon a different timeline. So you're looking at 90 days before the end of the discovery period for experts who are testifying for a party who's seeking affirmative relief. Anybody else, 60 days before the end of your discovery period. Disclosures for the most part include all the items that were listed in Rule 194 before, except for 3 new added disclosures. My favorite is the last one, which is you have to include a statement of compensation paid to the expert for their study and testimony in the case. I guess you could request it before, or you can figure it out in depositions before, but now you have to include it. The next thing is that you have to include an expert's qualifications and publications for the past 10 years. And then you have to list all cases where the expert testified as an expert in a trial or in a depot for the past 4 years. You don't need to include cases where the expert was testifying as to attorney's fees. Don't need to worry about that, but anything else you must include for the past 4 years. Okay, Rule 196, 197, and 198, all of these have the same change. And in essence, what happens here in Rule 196, which deals with requests and motions upon entry of property, requests for production, inspection of parties, interrogatories, and requests for admissions, right? That's 196, 197, and 198. Here, what happened is you eliminated service of discovery with the petition, right? That doesn't happen anymore. So in all cases filed on or after January 1st, you can't do that anymore. And a response to any of these three, Rule 186 through 198, the above noted a discovery, must be served within 30 days after the service of request. Okay, the next is our change number 17, which is Rule 277. And here you see the rewrite of, you see the legislative process happening here, right? What happened is that the rewrite is overturning the Texas Department of Human Services versus EB, which was a case that was decided in 1990. So what happens here is that first you see that there is individual jury questions for every ground for termination of parental rights for each parent and for each child. The second thing that you see is the best interest question must be predicated upon affirmative finding of at least one ground of termination. Okay, so how does this overturn Texas Department of Human Services versus EB? Well, that case required broad form questions, I guess like for terms of efficiency, that's what the court was thinking. And so they moved away from special issue questions. Now we see the pendulum swing back and we're moving away from broad form back to special issue. And that's what happens as a result of the rewrite in Rule 277. The next is a really simple change here. What it does is and you'll see this run true for the rest of the changes that we discuss in this presentation. You see an increase in the jurisdictional limits for claims in justice court. And here you see the increase from 10,000, we double it to 20,000 in small claims, debt claim, repair and remedy, and eviction claims in justice court. So that's 500.3. In 502.3, we see some superfluous text that was marked out, but other than that, no substantive changes. For the writ of certiorari in Rule 506.4, we see a term change, right? So before it used to say indigency, and now it says inability. So minor change here. And then returning again to those increases in relief requested maximums, we see that in Rule 509, this covers changes 21 and 22. Rule 509 discusses repair and remedy cases. Repair and remedy cases in order to comply with the changes that we saw in Rule 500, the relief requested maximum doubles. So we go from 10,000 to 20,000, and then the judgment amount in the judgment instrument also has to make sure that the recovery is increased from 10,000 to 20,000, but cannot exceed 20,000. In repair and remedy cases, those are usually they're filed in justice court by a residential tenant, and they're filing under Chapter 92, Subchapter B of the Texas Property Code. So boom, there you have it. You have 22 changes. And let's go ahead and open the floor to any questions, or Mac or Laura, if you guys have any comments or anything that you want to add, feel free.
So we do have 2 questions so far. The first question is, are we going to be able to distribute the slideshow to anyone that's interested so that they can use the hyperlinks that we provided?
I say yes.
All right.
I say yes, but I'll wait for authorization from Mimi before we distribute anything.
All right, and then the next
also
question.
You can.
Oh, go ahead.
I would say just email me, ping me. I'll send you all the links I have.
Great. And then, are there any penalties for a party who refuses to serve disclosures until requested by the other party?
Mac, what would happen? Like if someone was just like, no, you're on mute, hold on.
Oh, there we go. I'm unmuted now. I think what we need to do is we need to bring Laura into this too, because I was concerned about that myself because the way I see it, the initial disclosures are absolutely required. I mean, that's to keep you in I think it's jurisdictional. So the way I read it. So I think, the responsive action can be a motion to dismiss or a motion to exclude the petition or the claims of the other party. I mean, now this disclosure is required for both parties without a request. It's just required by the rules. I mean, in other words, you aren't following the rules. I'd like to, is Laura on? I'd like to have Laura's comments on that because she's the person that has to fight this in court every day.
Okay, yeah, I'm here to offer some perspective. Just like now, when you serve under the old Rule 194 for cases filed before January 1st, 2021, when a request for disclosure was filed with the petition, served on a party after service of the petition, if they don't respond, it's your burden to seek assistance with the court. And of course, you contact first the opposing party if they're represented by counsel or a pro se, as we deal with a lot in our subrogation practice over in the compliance division. Reach out to them, ask for their response, remind them of their duty to respond. And after a period of time, if they still haven't responded, then you have to seek assistance of the court. And because your discovery period is so much shorter in my mind, you've really got to be on top of that. You've got to be familiar with the court you're in and what their requirements are for filing discovery motions. A lot of them are going to require that you have conferred with counsel, and some have real specific requirements on how that's done. And so you're really going to have to stay on top of the due dates. Otherwise, it's at your peril because days are ticking away as to you being able to serve other types of discovery that you might want to know what their responses to these initial disclosures provide, so that you might want to tailor your discovery requests, interrogatories, requests for production. So you're going to have to seek involvement of the court.
Well, let me ask a specific question. Laura, I think that's a very good answer, but the question was if the other party refuses.
Well, that's when you file.
I mean, what you would do is you file a motion to compel discovery, wouldn't you?
Well, we understand that, but what happens if they still don't comply? Would you be filing a motion to strike their pleadings or a motion to dismiss?
Well, that's all way down the road. You would. Sure. My relief, based on these short time frames under these new rules, would be a request to extend the time period for the discovery, to enlarge the discovery period, because if the other side is not responding as they should, then it shouldn't negatively affect your handling of your case. And so seeking an enlargement of the discovery period would be something that I might include with a motion to compel. That way you can avoid game playing, and recognize here that it says when the disclosures are due, you can then after that point request other forms of discovery, but it doesn't say when they are provided. And so I've discussed it with other attorneys, and you would hope that other lawyers would be professional and would respond as they should, instead of playing games and not actually responding, because it says when it's due, not when the initial disclosures are filed.
Yeah, I
And
see what you mean.
I don't mean filed, I mean served.
Yeah, my concern was especially for, as you say, we deal with so many people who are not lawyers. And that's, that's going to be an interesting situation.
So I mean, my suggestion is to really be on top of your discovery in your cases and deadlines. You don't want it to turn around and bite you because you've given an extension or you've been lenient on demanding a response to these required initial disclosures. You don't want it to hurt your case.
Did anybody else have any other questions? If not, I don't see anything coming through the chat. I was trying to give somebody a minute, but if that's it, then
I had a
thank
feeling.
you,
that we-
Rebecca. Thank you, Garland. Thank you, Laura.
Thank you, everyone. I had a feeling that these rules are, there's so many of them and it's so large that people are going to need some time to think of questions because it's just overwhelming. It's a radical change.
Absolutely. And if anybody has any questions after the fact, if y'all think of anything, please feel free. I included my email and Rebecca's email in the chat so that if you need a list of the sources that we utilize to get these administrative orders and our research, they're very helpful in seeing the changes. Y'all, please feel free to email us.
Good job, everybody.
Thank you, Rebecca.
Rebecca and Garland, this is Jay. I just want to say what a great job you guys did. This was really, really wonderfully done.
Thank you.
Thank you.
Thank you.
We're
All right,
giving
well,
y'all a
thank
good
you,
job up.
everybody.
Thanks, guys.